like to call the September 9th, 2020, 10 a.m. meeting post-council to order. For the record, will be also remote and electronic. We're going to go ahead and do a roll call. We would ask you, when you make a motion or a second or you're speaking, that you state your name clearly. With the mass, obviously, make sure and speak loudly and clearly and ensure that you state your name. With that, I will go ahead and call the meeting to order. As the way of those that are going to be asked to be excused, Christy Morin will be out. I believe Bruce Bailey, is he on? Are you on the line, sir? He was having some technical difficulties, so he may be excused as well. If he comes on, then we'll go ahead and have him join. With that, we'll ask for an approval of the June 17th, 2020 meetings. Do I have a motion for approval? I have a motion to approve by Spence Austin. Do I have a second?
I'll second it.
Second by
John Crowley.
John Crowley. Any further discussion? Seeing none, we'll go ahead and move forward to quarterly reports. We have Lieutenant Jacqueline Moore and Lieutenant Alex Garcia, please.
So for the quarter of June 1st, 2019 to August 31st, 2019, investigations received 80 complaints, opened 27 cases, conducted 1 ALJ hearing, closed 6 with no action. We received 3 voluntary relinquishments. The first was for obstruction of justice and official misconduct. The second was for willful falsification of application to obtain certification. And the last was for sexual conduct on duty and lying under garrity. We reviewed 420 applications. 365 of those were basic training, 31 were dispatchers, and 24 were waiver reactivation cases. And then we have 79 open cases and 53 active investigations. Any questions on that? Okay, thanks.
Ms. Vitti, without further ado, we'll go ahead and move toward disciplinary cases.
Good morning, members of the council. We have a short calendar today, only 11 cases. The first case is Ricardo Aguilar. Is Mr. Aguilar or his attorney present?
He's not.
Ricardo Aguilar was employed by the Salt Lake County Sheriff's Office. The sustained allegation was assault, domestic violence assault. This is a Category C offense. The baseline is 2 years. The range is 9 months to 3.5 years, and post recommends 2 years. There are no aggravators or mitigators. There's a jury trial pending on January 28, 2021. Ricardo Aguilar was investigated for domestic violence, aggravated assault, and domestic violence in the presence of a child. The investigation concluded Aguilar put his hands on his wife's neck and pushed her back against a wall and briefly held her there. An internal investigation was conducted by Aguilar's agency that included a garrity interview. Aguilar told his agency that he and his wife were in an argument. During the argument, Aguilar went to their bedroom, turned on the TV, and lay down on their bed. Aguilar said this angered his wife, who started hitting his shoulder, so he used his legs and pushed her away from him, which angered her even more. Aguilar said she then jumped on him as he was lying on the bed and started hitting him again. Aguilar said he pushed his wife away a second time, then got up and put his hands around her neck and held her there for a little bit to get her attention. Aguilar also participated in a post-garrity interview and confirmed what he told his agency. During the post-interview, Aguilar was asked if he applied pressure to his wife's neck and said, "It's possible." A follow-up question was asked regarding the likelihood he applied pressure, and Aguilar said, 50-50. Maybe the time when I got up and put my hands on her neck, maybe I put some force on there. But as I recall, I just put my hands on her there to get her attention and tell her to get out of the house. This case was resolved with entry of an order of default. He is no longer employed by the Salt Lake County Sheriff's Office.
Any questions for Ms. Beatty? Seeing none, we'll go ahead and call for a motion.
Recommendation for 2 years suspension.
I have a motion to accept by Colonel Rappage. Do I have a second? Please state your name as well.
Spencer Austin, second.
Spencer Austin as second. Any further discussion? Those in favor?
Aye.
Any opposed? Hearing none. Motion passes. Next.
Okay, second case is Michael Cortez. Is anyone present for Michael Cortez? Seeing no one. Michael Cortez was employed by the Salt Lake County Sheriff's Office. The sustained allegation is lewdness. This is a Category D offense. The guidelines are, the range is 3 months to 2.5 years, and the guidelines baseline is 1 year suspension. Post is recommending a 1 year suspension. There are no aggravators and there are no mitigators. On April 6, 2020, Michael Cortez was investigated by a local police department for lewdness. Cortez and his girlfriend drove his personal vehicle behind a liquor store and engaged in sexual intercourse in the rear passenger seat. A local police officer was dispatched to Cortez's vehicle and observed Cortez having sex. After identifying Cortez and his girlfriend, the officer issued a citation to both for lewdness. Cortez later entered a guilty plea to be held in abeyance to the charge of lewdness and infraction. During the department and post-Garrity interviews, Cortez admitted to the conduct which constitutes lewdness. He resigned from his department before any discipline was administered, and he waived his right to a hearing.
Any questions for Ms. Beatty?
Yes.
And he pled guilty or was convicted?
Plea in abeyance.
Plea in abeyance.
Yes.
Any further questions? Go ahead and ask for a motion.
I make a motion to follow council's post recommendation for a 1 year suspension.
We've got a motion from Chief Soap to follow post council's recommendation. Do I have a second?
Second.
Got a second from Colonel Rappage. Any further discussion? I'll go ahead and call for the vote. Those in favor?
Aye.
Any opposed? Seeing none, we'll go ahead and ask for the next case, please.
The next case is Taggart Foyas. Is anyone present for Mr. Foyas? If I'm saying that correctly.
See no one.
No one appears to be present. Mr. Foyas was employed by the Tooele County Sheriff's Office. The sustained allegation is driving under the influence of alcohol or drugs or a combination of both, which is a Category D offense. The range for this offense is 3 months to 2.5 years. The guidelines call for a baseline of 1 year, and post is recommending 1 year. The aggravator in this case is that he was in uniform and on duty. The mitigator was that there was no evidence of intent and no signs of impairment were observed by the officers. There is no criminal case in this matter. Taggart Foyas was investigated by his agency for driving under the influence of alcohol, drugs, or a combination of both. The investigation disclosed Foyas went to break with some other officers who were able to smell the odor of alcohol coming from Foyas. Foyas submitted to 2 breath tests and 1 blood test approximately 4.5 hours after his shift started. The 2 breath tests showed results of 0.034 and 0.031 blood alcohol content. The blood test showed a result of 0.033 blood alcohol. The average burn-off rate for alcohol is 0.015 per hour, which would have placed Foyas over the legal limit of 0.05 alcohol content at the time his shift started. Foyas would have been near 0.09 alcohol content when he started his shift. During Garrity interviews with his department and post, Foyas admitted to drinking mixed alcohol drinks until 8:30 p.m. the night before. He said he did not feel intoxicated when he went to bed or when he woke up. He said he did feel groggy when he woke up, but it attributed to the 2 over-the-counter sleeping pills he took that night. He did not drink any alcohol when he woke up or while he was on duty. He believed a possible reason for his positive alcohol tests was an undiagnosed stomach issue that caused him to digest things more slowly than the average person. He waived his right to a hearing.
Any questions for Ms. Vitti? Hearing none, I'll go ahead and call for a motion.
Motion to accept post-counsel.
I have a motion from John Crowley to accept post-counsel's recommendation. Do I post-staff recommendation? Do I have a second?
Second.
Yes, second from Spence Austin. Any further discussion? I'll go ahead and call for the vote. Those in favor? Aye. Any opposed? Seeing none, we'll take the next case.
Elaine Franco. Is anyone present for Elaine Franco?
Yes.
Should I hear a yes?
Yes.
Is Ms. Franco present or Ms. Franco's attorney present?
They are. Thank you.
For the record, Ms. Franco and her counsel are here.
Okay.
Go ahead, Ms. Vitti.
Thank you. Elaine Franco is currently employed by UPD. The sustained allegation is a BCI violation. This is a Category E offense. The range for a Category E is a letter of caution to 1.5 years, and the baseline is 6 months. Post is recommending 3 months. The aggravator in this case is that she disseminated the information, and there are no mitigators. On December 23, 2020, Elaine Franco was asked by a friend to run a license plate to ascertain who the owner was. She then forwarded a picture of the vehicle registration information obtained by the BCI search to her friend, who posted the information on Facebook. She was investigated criminally. A charge was screened but not filed. During the Garrity interviews with her agency and Post, Franco said she knew it was wrong to access the BCI record of the license plate and share it with her friend. She said although she knew it was wrong, a man had stolen thousands of dollars from the friend and to whom she sent the picture. She did not know her friend was going to post the information on Facebook. Franco's agency determined Franco had violated the criminal code and department policy on accessing and disseminating BCI-controlled information. She received 40 hours off, loss of her next pay increase, and the ability to test for sergeant in the next testing cycle. She waived her right to a hearing. Would Ms. Franco's attorney or Ms. Franco like to address the council?
Yes. Is it okay to have the mask off for this moment?
Fine. Thank you.
And feel free to take yours off too. Ladies and gentlemen, we appreciate the opportunity to be here. Not all offenses are created equal. Within a single offense, such as a BCI violation, there are wide gradations. In here, accessing a BCI record for a personal offense can be a crime, but in this case, this was screened and she was not criminally charged. However, she does admit that she accessed a BCI record for a purpose not permitted by her department policy. However, it's not your typical BCI violation, which, as you all know, can be an ex-spouse is now dating a new person, you have a new neighbor that's moving in across the street, you're following up on a boyfriend, or you want to see the record of a coworker. Those are all typical BCI violations. This is not typical. For what we have here, for the reasons I'll get into. Really, this was essentially for a law enforcement purpose, but it was to help a personal friend receive justice. So what happened here, and I'm not just making this stuff up, I have a 9-count felony information that's before me for an individual named Trace Conlon. And what happened from that probable cause statement there is last year, Officer Franco's best friend, Nisha Wright, again, best friend, former roommates, they lived together for 4 years, they've traveled together, it's just really her best friend in the world. Her friend Nisha agreed to pay a man, Trace Conlon, to install new kitchen cabinets in her home. They agreed on a price of $14,400, and she paid half up front, $7,200, in September. Mr. Conlon then got Nisha to pay an additional $3,600 on October 15th. In November, Conlon asked for more money, which was paid. Nisha and her husband tried to arrange install dates with Conlon, but he always stated that the cabinets were just never ready. In December, Conlon tried to change the terms of the deal, and then Nisha and her husband just finally contacted the cabinet distributor, who said, well, these orders were never placed. So this large amount of money that they paid Conlon never went to purchase the cabinets. They were out nearly $12,000. This is her best friend. So Nisha, of course, was victimized. She was hurt. She finally realized that she was taken and she was defrauded by what would end up being a serial con artist. She contacted the authorities multiple times, and she felt like she wasn't getting anywhere. They continued to tell her that this appeared to be a civil matter. Well, it wasn't a civil matter. Eventually, in April, this information was charged with 9 felony counts, most of them second-degree felonies, and the rights were included on this. This is out of, just for the record, this is out of the 2nd Judicial District in Weber County, State v. Trace Conlon. So, what happened then was Nisha contacted her best friend, who again, she was exasperated, she was victimized, and she wanted to prove that this was more than just a civil matter. She wanted to build a criminal case against Conlon so that a criminal case would eventually commence against him. Again, this is well before a criminal case was ever filed. This is in December. So Ms. Wright told Officer Franco she looked into Conlon's history as much as she could. She found a history of defrauding other people, a history of never putting his name onto certain items of property, and then in her understanding would then just declare bankruptcy and then re-victimize other people. So she finally saw Mr. Conlon's vehicle, pulls his license plate, and she asked her best friend to see if this license plate is actually registered to Conlon. My client did run the license plate and did give information from that and took a screenshot of it. And that was that. At least that's all she thought it was. She knew it was against policy. Her intent was to help someone receive justice, but she knew it was wrong. Well, unfortunately for her best friend then posted that on social media, and my client had no idea that would happen. So she knows she made the wrong call, even though her desire was a true and just desire. Now let me just tell you a little bit about Officer Franco. For 6.5 years, she's been involved in law enforcement. For 3 years, it was first in Logan, and 3 years at UPD. She went to Weber State and to Utah State, graduating criminal justice. She is an exemplary officer. She was featured on Beyond the Badge by KSL, stating that she's a first-generation U.S. citizen. She earned a reputation as a positive and energetic officer who is highly respected by her coworkers. She became an FTO early on. Get this. She was a liaison with the Hispanic community, participating in a Spanish radio program up there in Logan to inform Spanish-speaking people of Utah's laws and to share crime prevention tips. With her own money, she paid for the room for a homeless father, and 2 kids to stay in. She was awarded the Logan Police Department Patrol Officer of the Year in 2015. At UPD, she received the Chiefs Award. At UPD, she received the Taylorsville Chiefs Award. Her team just recently received the Distinguished Unit Award. At UPD, she's been the Employee of the Month, and currently, and this is a great thing, she's been employed at Taylorsville High School as an SRO, and she's in her 3rd year there. She's not only a law enforcement officer, but she's a counselor to many. She's a teacher. From her own time, she volunteers as an assistant track coach. She's praised by supervisors and by all those around her. The school last year asked students, who was the adult that they most trust? 25 of them said, Officer Elaine Franco. Those kids need her there. Not all BCI violations are alike, ladies and gentlemen. It's difficult to imagine one like this. But the mitigation is very strong. Her heart was in the wrong place, but she just made, frankly, the wrong call. But here with this council, what you've been very, very consistent at is that when there's when there's a lot of mitigation like this one, you're proportionate, you're consistent, and it's always a letter of caution. That's what we're asking from this. She learned from it. She made the wrong call. She'll never do something like this again. She's a fantastic officer. Consider her character, consider the credit she is to the profession, consider where she's needed in this community, and that those kids need her out there at Taylorsville High School. Rather than 3 months, we just sincerely just request a letter of caution.
Oh, sorry. Okay. I just want to convey to the council how much I love being a police officer. To me, this is not my job. It's who I am. It's part of who I am. And I love serving my community. the accolades I've gotten haven't been for doing cool stuff. It's been for just treating people with kindness and dignity and respect. I love to help people. That's my favorite part of my job, and be there for victims when they need it the most. And that's what happened here. That the victim happened to be my best friend. And the friend and the police officer kicked in. I took an oath to protect and to serve and to help those in need, and that's what I thought I was doing, and I know I was wrong in doing so. I thought with my heart instead of my head. So yes, I take responsibility for what I did, and I realize my actions not only affected the gentleman whose plate I ran and was posted out there, but my actions have also affected my pending suspension, have affected my husband, my kids, my administration at the school, my chief, my area partners, my students. And that's the part that's the hardest for me, is that I've hurt people. I never meant to cause any harm. It's not who I am. I'm a Christian. And it's just not who I am. I don't hurt other people. I've learned a valuable lesson from this that I will carry with me for the rest of my life and my career. And I just sincerely want to thank you for taking the time to listen to me and to hear my case, and that I willingly accept whatever you choose is best in your determination. Thank you.
Any questions? Ms. Beatty, anything additional?
No, sir.
Alan Swanson, I'd like to make a motion.
Is that Chief Swanson?
Yeah, Chief Swanson, Lake PD. I'd like to make a motion, just based on the intent here, and also considering the fact that her local agency already has punished her pretty heavy. I would make a motion for a letter of caution.
So we got a motion from Chief Swanson for a letter of caution, and a second from Sheriff Noel for on the same motion. Is there any additional comment? That will go ahead and call for a vote. Those in favor? Aye. Any opposed? Seeing none, the motion passes. Thank you.
Okay, the next case is Colton Johansson. Officer Johansson, or anyone representing Officer Johansson present?
Officer Johansson is here.
Okay. Colton Johansson, who is currently an Ogden City police officer, had the sustained allegations of let's start over. A sustained allegation in this case is a BCI violation. This is a Category E offense. The range is a letter of caution to 1.5 years. The baseline is 6 months, and post is recommending 3 months. The aggravator in this case is there were multiple occasions. The mitigator, though, is that he did not disseminate the information. Charges were screened, but the city prosecutor declined to file. Colton Johansson was investigated by his department for unauthorized access to BCI protected records after his department received a complaint from Johansson's ex-wife that he was running a background check on her boyfriend. Johansson's department obtained a BCI dissemination access log report, which confirmed Johansson queried 2 driver's license searches through BCI on the boyfriend. During the department and post-Garrity interviews, Johansson admitted he unlawfully accessed the ex-wife's boyfriend's information through BCI multiple times. No charges were filed. His agency sustained the allegation of unlawful use of BCI protected records. He was suspended for 2 days without pay, and he waived his right to a hearing.
Mr. Johansson.
Nothing further.
Also, for the record, Mr. Johansson has a letter from Chief Randy Watt. Are you in possession of that as well?
I am.
Okay. And you can feel free to read that if you would like.
You would like me to read it?
If you would like to. That's your choice.
Okay. It's quite lengthy.
It's fine unless council would just like to read that, assuming everybody's in possession.
I'll read it if that would be appropriate.
Completely your call on that.
Okay. All right. I appreciate your time. Good morning. I'm Colton Johansson. I'm considered a master officer of the Ogden City Police Department. I've been an officer with Ogden City for 19 years. I also have been a deputy for the Weber County Sheriff's Office for 8 years prior to that. So I've been in law enforcement for 27 years. The facts in this case, about a year and a half ago, my ex-wife filed a complaint with the Ogden City Police Department. My ex-wife and I have been divorced for over 9 years. She filed that complaint. One of the issues of many was that I ran background checks, and she listed 6 to 7 of her boyfriends that she had prior to that. Her current boyfriend at the time had been picking up my children with my ex's car. So he wasn't using his own vehicle, he was using my ex's. This concerned me greatly because of my children. I didn't know what his status was. I consulted or tried to get a hold of my ex, and she would not respond to any information about that. I did run a driver's license check on the boyfriend. At that time, I was concerned for the safety of my children. I didn't know why he was driving without a vehicle, why he, wasn't with her, my ex, but he was picking up my kids, and I was concerned for that. Noting that there was none of this information was given to anybody for any reason. It was me personally. I am sorry for that. One of the allegations was that there was multiple times I accessed the BCI. The one during the investigation was that during the one time I checked it, there was a half an hour period of time. The only thing that I can recall, or that I don't recall, but the only thing I could think of was that I must have got sidetracked and it timed out, so I actually ran it again within 30 minutes. So those are the 2 times that I ran the BCI. Just a little side note on this. Some of the additional complaints that she has filed over the last year and a half with me has been theft, assault, trespassing, harassment, stalking, residential burglary, vehicle burglary, child abuse, child neglect, custodial interference, and kidnapping. All these accusations have been investigated by the Davis County Sheriff's Office, Weber County Sheriff's Office, North Ogden Police Department, North Ogden City Prosecutor's Office, Weber County Attorney's Office, where they completed full criminal investigations on this. Also involved in this is obviously BCI, the Attorney General's Office, Post, as well as DCFS with Davis, Morgan, and Box Elder counties. All my 7 kids, we have 7 kids together, they were all interviewed at multiple different agencies. The reason why I bring this up is because it's a continual thing in my career since we've been divorced. All of these have been unfounded and unsupported. The Weber County Attorney's Office did review this case. Their review stated that it was not criminal in nature, and that if any other officer had ran the driver's license check, we wouldn't have this issue. Ogden Police Department took it seriously. They did a full investigation, which took months with all these other allegations. In the end, they did give me 2 days off without pay, which affected my evaluation, which affected my raise, as well as my any kind of bonus. There was a letter attached to my file, and in that letter states that we are not allowed to go anywhere within any specialties within 3 years. And then finally, at the end of that letter, It states in there if there's any other disciplinary action that they would terminate me. So I feel the Ogden Police Department handled it professionally. They handled it in an efficient manner. Just a side note, 27 years in law enforcement. I have great honor for what I've done and what I've been a part of. I could go on with all the things that I've been associated with over 27 years. But this is only my second time in 27 years that I have received any kind of disciplinary action. I'm truly sorry for what I've done. I shouldn't have ran that. I was concerned for the safety and wellness of my children. I also apologize for hundreds of hours that have been put into an investigation with criminally that resulted from my ex filing complaint after complaint. And unfortunately, the rulings today, I don't foresee this stopping. I'm in the process of filing a cease and desist with the civil courts against her. I feel that the Ogden Police Department has taken the appropriate action in disciplining me, and ask that post here would recommend or reconsider the 3-month suspension. I'll read the letter from my chief. I appreciate the chief and the support that he has given me. If you bear with me, we'll go real quick. It says, Ogden Police Department Master Police Officer Colton Johansson is appearing before you in accordance with the hearing proceeding listed in post letter dated June 24, 2020. As the Chief of Police of Ogden City Police Department, I am writing this letter in support of the MPO Johansson for use in this process. Master Officer Johansson is an 18-year-old veteran with the Ogden City Police Department. During these years, he has received 2 distinguished unit citations, 14 excellent work awards, 7 letters of commendation, and once been Employee of the Month. He holds a Bachelor degree of Science in Criminal Justice with Weaver State University and has successfully completed the stringent requirements to be promoted to the Master Officer. He has only one previous incident of disciplinary action in these 18 years with Ogden City, exemplary service to Ogden City as well as Weaver County in the state of Utah. In 2019, the Ogden City Police Department conducted an investigation, the result of a complaint by the ex-wife of Officer Johansson alleging illegal behavior as a result of unfavorable child support ruling by a judge. Officer Johansson's ex-wife had made numerous previous complaints of her ex-husband over the years following their divorce. Each of these complaints followed around the time of an unfavorable ruling or situation in regards to child support, child custody, or alimony. Each of the previous complaints was found to be non-sustained. Officer Johansson's ex-wife went as far as to make complaints of child abuse to North Ogden Police Department, who spoke to each of the children and quickly unfounded the case. Ms. Johansson has for years been attempting to use whatever parts of the system she can to punish her ex-husband. In the case at hand, the Ogden Police Department conducted an internal affair on this complaint as we did all other complaints. In this case, we found the complaint to be sustained. Officer Johansson did inappropriately access the UCJIS system. As in all cases wherein state law is implicated, we submitted the findings of to the Weaver County Attorney's Office for a review and finding. The County Attorney's Office declined to file as the case did not constitute criminal conduct. In discussion with the county attorney, the point was made that there was sufficient cause to query the system for the information, and had it been another law enforcement officer than Officer Johansson, then there would be no issue. Ogden Police Department issue was the conflict of Officer Johansson querying the system in his own behalf. The reasons for the query of the system were valid. However, Officer Johansson should have made complaint to his supervisor, and the supervisor could have assigned an investigator and handed the situation off to an outside agency. Ogden Police Department's policy requires these actions of Officer Johansson, and Officer Johansson is honest in admitting he knew that and made a decision not to do, but to query the system and keep the information to himself. Master Officer Johansson was disciplined and given 2 days off without pay. The disciplinary was being consistent with previous allegations of the same type. Officer Johansson's ex-wife had made been made aware of the outcome, and she was very unhappy. She then made the complaint to the Utah Attorney General's office, which sent her to Post. As a result, Post reaching out to OPD and instituting this investigation. Post is recommending a 90-day suspension of Master Officer Johansson, Peace Officer certification. That is an overkill in my opinion. Besides sanctions, Johansson's behavior following the recommendation will result in significant impact at Ogden's operations. Officer Johansson is a school resource officer. A suspension of any kind will result in OPD removing a respected, experienced, qualified, and trained SRO from the school and attempting to get the school district to agree to an unfamiliar, untrained, unqualified SRO for an internship or internship period. Not only is OPD adversely affected, but so is the largest high school in the Ogden School District. It is my opinion that Master Officer has been sufficiently punished. A notice of discipline in an otherwise stellar professional file, 2 days off without pay, a potential for termination of employment should any other disciplinary action arise is sufficient punishment, especially when the nature of the originating complaint. I respectfully request that the Post Council not support Post recommendations and find a more appropriate resolution. Thank you.
Thank you, sir. Any questions from council? Ms. Beatty, anything else?
Chief Swanson, I'm ready to make a motion.
Got a motion from Chief Swanson.
Yep. So first of all, I'd like to say that I think under the circumstance where this happened several months ago, time actually would already be served, and so there wouldn't actually be a suspension. But with that said, given the circumstances and also given the fact that the information was not disseminated, I would make a motion for a letter of caution.
So we have a motion from Chief Swanson for a letter of caution. We have a second from Chad Soph. Any further discussion? Hearing none, I'll go ahead and call for the vote. Those in favor?
Aye.
Aye. Any opposed? Seeing none, the motion passes.
Thank you. Thank you.
Okay. The next case is Troy Leary. Is Mr. Leary present, or his attorney, his counsel?
Yes, they're both present.
Okay. Mr. Leary was an officer with BYU Police Department. The sustained allegation is sexual conduct on duty. This is a Category B offense. The range is 1.5 years to revocation. The baseline is 3-year suspension, and Post is recommending 3-year suspension. There are no aggravators and there are no mitigators. There was no criminal case. Troy Leary was investigated by his department after he disclosed he engaged in sexual conduct on duty. Leary cultivated a relationship with a dispatch supervisor who worked for the same department. Leary met the dispatcher several times from April to October of 2019 and engaged in sexual conduct while he was off duty. In October, Leary met with dispatch supervisor while he was on duty while working a graveyard shift. The dispatch supervisor entered Leary's patrol vehicle and sat in the front passenger seat. Leary participated in what he called heavy petting and digitally penetrated the dispatcher supervisor's vagina underneath her clothing, which brought her to climax. In November 2019, Leary confided in his sergeant and told them about their affair. The sergeant notified his chain of command, and an IA was initiated on Leary. During the department interview, as well as the post-Garrity interview, Leary confirmed that he was on duty during the sexual conduct that occurred in October. Leary said he was in his department uniform during the encounter. Leary said this was the only time he engaged in sexual conduct while on duty. He said there were other times he engaged in sexual conduct with the dispatch supervisor, but he was not on duty during those instances. Leary's department sustained department policy violations, and he was given the option of resigning in lieu of termination. He waived his right to resign. That's all.
Mr. Leary and counsel.
Thank you. My client admits that he engaged in sexual conduct while on duty. That's not in dispute. But we do believe that there are mitigating factors, and I'd like to address that, and we'd ask for an opportunity in the recommendation of, and the council to find for 18 months. And as I was thinking about how to address this, I was thinking about why this is in statute, why something that's not against the law is in statute and carries such a severe penalty for an officer. And obviously, I think the first thing that comes to mind is obviously you don't want to have an officer engaged in sexual conduct while on duty in case there's an emergency. That wasn't the case here. Obviously, my client engaged in sexual conduct with an individual while on duty, but it was in the middle of the night. It was during a very slow period of time. There was no traffic. There was no emergencies to respond to. There was nothing that he missed in performing his duties as an officer. The second reason that I think that this would be in place with respect to being in place with the statute is the fact that you have a situation where you have an individual that is in power, and they could use that power to get themselves or coerce somebody to get into a relationship. That clearly is not what happened here. This was a consensual relationship that was instigated by the supervisor, the dispatch supervisor, and it was a consensual relationship where neither party, in essence, used their authority or their power to persuade the other into engaging into the relationship. The third reason why I think this is in statute is because of what it does to the profession. You know, law enforcement is a profession, and it's important that law enforcement professionals are held in high esteem, in good regard. And that only happens when people are acting in a professional way. And clearly my client didn't act in a professional way here. However, he has been an exemplary officer. He served 21 years with West Jordan before going and working with BYU. He's never been in front of post council. He's received commendations with respect to his work. He was referred to me by Sheriff Rigby. He has other law enforcement agencies that he would like to go work for, that would like to hire him, but he wants to take care of this and clear this up first, obviously, and needs to clear this up first. He is, as I said, an exemplary officer that has never had any disciplinary issues like this in the past, and really deserves the benefit of the doubt here. The other mitigating factors that I think that you need to really consider here is the fact that this would not have come to light but for my client bringing it to the attention of his supervisors. He self-reported it. He addressed it with them. He also asked his agency to report it to Post. And so that's the reason why they reported it to Post. But for him actually asking them to do so, they wouldn't have reported it to Post. Bottom line is he took ownership for what he did here. He didn't try to, again, blame anybody. He's very remorseful. He's going through counseling to repair the damage that he's done. His wife is here with him, and they have worked very hard on their marriage since this happened. He knows that he needs to do better in the future. And, again, we would ask that you consider those mitigating factors and give him 18 months suspension as of the date that he resigned from Provo, or BYU, which was December 19th, 2019.
I just wanted to say thank you for your time. I know sometimes these decisions are hard on you as well. Sergeant Adams as well. Thank you for the time and to look into it and see our side. Is this better? Sorry. I just wanted to kind of point out again that what Blake, my attorney, said is this was a very difficult decision to start off to go in and tell my sergeant. I was like, how do you go in and tell your sergeant, hey, screwed up? And I've tried to make that correction for my mistakes. I've tried to correct that the best I can since then. And very sorry for my behavior, my actions, for the department, I'm sorry for them. I'm sorry for my wife and my family that have been going through this since, and to all of the law enforcement community. I know my actions were completely wrong, and I'm doing the best I can to correct those actions now and face up to them. I don't think I've ever told anyone that I didn't do anything wrong. I know I've done wrong, and that's why I stand here and hopefully correct that and be able to prove that I'm a better person than that. It's not how I wanted to leave law enforcement. After total time now is 22 years, up to December of last year. But again, thank you for your time.
Any questions for Counselor Mr. Leary? Seeing Ms. Beatty, anything else?
No, thank you.
Seeing none, I'll go ahead and call for a motion.
Move we accept the recommendation of Post.
I have a motion from Colonel Rappage to accept the recommendation of Post staff. Do I have a second? I have a second from Victoria McFarland. Any further discussion? Hearing none, I'll go ahead and call for the vote. Those in favor?
Aye.
Any opposed? Seeing none, the motion passes. Thank you. Thank you for your time.
Okay, the next case is Elon Matatek. Is Elon Matatek or Elon Matatek's attorney present?
Elon?
So Elon Matatek is present?
Yes, she is.
Okay, thank you.
Would you like to... go ahead, Ms. Beatty.
Yeah. Okay. Elon Matatek was an officer with... Elon Matatek was employed by the Salt Lake County Sheriff's Office. The sustained allegation in this case is assault, which is a Class C offense. The range is 9 months to 3.5 years, and the guidelines baseline is 2 years. Post is recommending 2 years. There are no aggravators and no mitigators. No criminal case. On January 31st, 2020, Elon Matatek was investigated by a police agency in another state and her department for assault. The investigations disclosed that on January 28th, 2020 and January 31st, 2020, Matatek assaulted her girlfriend. On January 28, 2020, Matatek and her girlfriend began to argue, which led to pushing each other. Matatek punched her girlfriend in the eye, causing a black eye. On January 31, 2020, Matatek and her girlfriend were at a bar when they began to argue. Matatek's girlfriend walked away and sat on a bench. Matatek followed her girlfriend and shoved her off the bench into a nearby wall. The case was screened with the county attorney, but charges were dropped against Matatek because her girlfriend could not afford to travel back to the city where the crime occurred. During Garrity interviews with her department, Matatek admitted she may have hit her girlfriend in the face while pushing her, causing the black eye. Matatek also admitted she pushed her girlfriend off the bench. During the Garrity interview with Post, Matatek admitted to punching her girlfriend and causing a black eye. She also admitted to pushing her girlfriend off the bench into a wall. She said she was extremely intoxicated during both events. She admitted her actions constituted assault. Matatek said she has quit drinking alcohol and has started attending counseling. She waived her right to a hearing. That's it. Ms. Matatek,
would you like to address counsel?
So I just wanted to say that for everything that did happen, I take full responsibility for what happened. I'm not using it as an excuse, but I know that had I not been drinking at the time, none of it would have ever happened because I'm not a violent person. That's not me. I did stop drinking. The last time I drank was March 11th, and I'm still going to therapy sessions, and I don't have any plan whatsoever to drink. Moving forward, like through all this, losing my job with the sheriff's office was something that probably hit me harder than anything that I've had to deal with in my life. And I don't have any excuses for anything that I did. I take full responsibility for what happened. But I do know that my career and everything, I do want to keep it and move forward and try to move past this at some point. That's all.
Thank you. Any questions from council? Sheriff Noel?
Should this not be classified as a domestic violence? It's an assault domestic violence?
You guys cohabitated together, I assume?
We're not anymore.
Investigators?
Sergeant Barnett, it should have been classified as a domestic violence assault. It would not change the category that the crime falls into, though, or the recommendation.
Thank you. Thank you. Any further questions? Go ahead and ask for a motion.
Yeah, I just got one question.
Go ahead,
Chief. I missed it. Was there a conviction on this?
No, there was no conviction. Oh, sorry. No, go ahead.
There were charges were screened, but they were not filed due to the inability to get all the witnesses and everyone to the trial. Case was dismissed.
Thank you. Any further questions? Hearing none, I'll go ahead and call for the motion. Is there a...
I'll make a motion to accept
Got a
staff recommendation.
I've got a motion to accept staff recommendation. Do I have a second?
Second.
Got a second. Ms. Spence Austin. Any further discussion? Hearing none. Those in favor?
Aye.
Any opposed? Oh, do we have any opposed? Sorry. Seeing none, the motion passes. Thank you. Thank you, ma'am.
Okay, the next case is Devin Park. Mr. Park or Mr. Park's attorney, are you present?
Devin Park is.
Devin Park was employed by the Utah Highway Patrol. Is he up there? Sorry, I can't see.
Yes, he is there. He is. We're ready.
Okay, thank you. The sustained allegations were sexual battery, lying under garrity, and disorderly conduct. This is a Category A offense. The range is 3 years to revocation. The guidelines baseline is revocation, and post is recommending revocation. The aggravators in this case are that there were multiple charges. There were no mitigators. No criminal charges were filed. But he was terminated. He has been terminated from Utah Highway Patrol. Devin Park was investigated by his agency for sexual battery with intentional rubbing over the clothes, the penis of, sexual battery for intentionally rubbing over the clothes the penis of another trooper, pointing his duty weapon at the same trooper, pointing his taser on multiple occasions at the same trooper, and pointing the laser of his taser in another trooper's eye. During multiple garrity interviews, Park denied or made conflicting statements about each event. Park was investigated criminally. The charges were screened, but the attorney's office did not file on the sexual battery because the victim trooper did not wish to pursue the charges. The attorney's office did not file any other charges because of the low probability of prosecution for horseplay. Devin Park defaulted in this case. I have nothing else.
For the record, Colonel Rappage will recuse himself on this case. Mr. Park?
I'm grateful for the opportunity to have the chance to speak my part in this investigation. I'd like to tell a little bit about my career. Throughout this entire investigation, it seems that there really is no hold to the aggravated assault allegation. It's a he said, she said. It didn't happen. I never pointed my weapon at the other trooper. The sexual battery that was alleged, the allegation was in the cab of a semi-truck. I'm happily married. I did not intentionally touch the other trooper's penis. After the matter, unfortunately, I made jokes about it because of the relationship that I felt the other trooper and I had. Had I known I had sparked that much contention with him, I would have addressed it immediately. I was hired by the Utah Highway Patrol in 2015. I was a good trooper. In the 3.5 short years that I was employed, I was a crisis intervention team officer, a field training officer, and a member of the state special emergency response team. Shortly after I had made a commitment to join the CERT team, I was approached by a captain with the Utah Highway Patrol asking if I had interest in joining the governor's detail, which I was very interested in. It's something that I had wanted to do even before getting with the Utah Highway Patrol. I was also approached by a sergeant asking if I had interest to be a polygraph tech for the department. Again, these were great offers that I had a lot of interest in. However, I had made a 2-year commitment to my CERT team leader, Wyatt Weber, and I had intended to keep that word and to work hard for him and for the team. I think this shows a lot about my integrity. My life has been geared towards law enforcement. My education, I have a bachelor's degree in criminal justice. I've worked hard my whole career. I have never had an integrity issue my entire life. This investigation was very intimidating because as it went on, more and more allegations were coming up. In 2017, I was called into my sergeant's office, which at the time was the time of the handgun incident that was alleged. The sergeant didn't address me pointing a handgun. He had concerns about me clicking the handgun in my holster. I had a tic when I was doing reports. I would click my gun in my holster. This is the same sergeant who said during his interview with Internal Affairs that I was a good trooper and that the trooper complaining was needy, whatever that meant. And upon being interrogated about his failure to act on the complaint, he quit, retired, and left the patrol. Had this been addressed then, it would have been taken care of at the moment, and I would have remembered a lot of the things that unfortunately are being held against me as lying. Fast forward to 2019, I was called into my lieutenant's office to write a memo on this, which was this incident, but at the time I had no idea what he was talking about. The only information I was given was that a trooper had alleged that I pointed my duty weapon at him. There was no dates, there was no details, nothing, and at the time I had completely forgotten about the incident in 2017 because I knew I never pointed a gun at him, and I didn't know that this is the incident that he was talking about. Between my first internal affairs investigation and my second, these things started to clear up in my mind. I had a lot of time to think on this incident, and I actually called the lieutenant to inform him. And it really turned against me because I felt like I was doing the right thing, bringing up information, trying to help with the investigation. And instead of it being that way, they said that I was withholding that information from the first interview, and because they had threatened with polygraphs and more evidence, they felt like I had succumbed and was then admitting guilt. To this day, I still don't admit to pointing a gun at the other trooper. I've never pointed my duty weapon at him, never sexually assaulted him. I am guilty of horseplay with taser. It happened many times throughout my career between me, high-ranking sergeants, lieutenants, different troopers. At the time with my first interview, again, I was extremely intimidated, and so I was trying to recall. They were very open-ended questions. They weren't very they were some of them were direct, but other were extremely open-ended, and it was hard to try to recall specific events. There was no dates, there was no timeline or anything. And again, after time, considering what happened, I had brought that information up and said, you know what, there's a lot of horseplay that went on with the taser, and these incidents probably did occur. Again, the picture is trying to be painted that I just lied throughout this entire investigation. There's no backbone to the allegations that have been made against me, and so it's sitting on this Garrity violation. I never pictured myself in this situation. I probably should have gotten an attorney early on. I didn't because I downplayed what was going on. But that being said, especially with what's going on right now with the public outcry for law enforcement, I think we need good police officers. There's officers unfit for duty that are dropping left and right. I'm young. I'm willing to serve, and I've done a good job thus far, and I've never had an integrity issue throughout my whole life. This is something that I've definitely learned from, and will never find myself in this situation again. The one thing that I have learned about this is if I had honestly lied throughout this entire investigation, I feel like I'd still be employed with the Utah Highway Patrol because I could just deny these allegations and there's nothing that would uphold what was being said. But again, I believe in integrity, so I was trying to do the right thing by answering questions the best that I could recall. Unfortunately, they just didn't come to my memory at the time that they should have. Thank you for listening. Thank you for taking the time to hear me out.
Any questions for Mr. Park? Chief Soph?
In the statement of facts we have before us, it said you were quoted as saying what happens in the cab stays in the cab?
Yes, sir.
Twice?
Once was right, yes, sir.
And it's on audio recording?
It is my dash cam video, yes, sir.
So, can you explain what you're talking about when you said that?
Yeah, so, again, that quote, what happens in the cab stays in the cab, I was just quoting from what happens in Vegas stays in Vegas, again, playing on the thought that with the relationship that I had with the other trooper. I don't deny, and I've said this throughout my entire investigation, I don't deny that something happened in the cab, but I know I didn't intentionally touch or grab his penis. Again, it was tight quarters. We were inventorying the vehicle. I could have swung and accidentally tapped him, not knowing that he had, been enraged and just thought that I was trying to sexually gratify him. That wasn't the case, and so when we were outside of the cab, that's when I said that, and that was my intention of saying that.
Okay, on the other question I have is it says that you initially denied pointing your gun or your taser at the other officer, correct?
Yes, sir.
And then later it said, I did it, I just can't remember. That's different. But then later you admitted pointing your taser at the officer, not just his foot?
So,
is that correct?
So, again, there were 2 investigations with Internal Affairs, my department. I want to say I've never admitted to pointing my duty weapon at him. I have pointed my taser at him. Again, I was trying to be extremely careful with the answers that I was given, and the questions there were. When I was being questioned about pointing the taser, it was, was it at his back, chest, and groin? Was it at his foot? Was it at other troopers? And I'm trying to recollect and remember exact moments. And again, I know that horseplay with the taser had happened, but I didn't recall specific incidents of me actually pointing it at his chest, at his back, at his groin. I did remember the incident with the foot, which was what I thought the handgun incident was all about in the first place.
Question. Mr. Park, in our statement of facts, it says on October 29, 2019, you called the OPS investigator 2 more times and reported you remembered pulling your duty weapon and pointing it at another trooper. Are you saying that's inaccurate?
That is inaccurate. And I actually requested in my post-investigation that the audio be played because I went home and listened to the audio. I had Grandma requested the report with the Utah Highway Patrol, and this conversation was between Lieutenant Troy Denny and I. And this was between my first internal affairs investigation and my second. And I had remembered this incident that happened back in 2017, and I was very specific to tell Lieutenant Denny, I'm not saying I pointed it at him, but I explained the circumstances and explained that my duty weapon was out at the time. I had press checked it, I had cleaned it, and I was checking my duty light. It wasn't pointed at him, so that is inaccurate to say that I called and said, yeah, I pointed my duty weapon at him, because I never said that.
Victoria. So related to the first count, and you've talked a lot today, but are you saying that just never happened? That the sexual battery just never happened?
So, again, I'm saying that whatever happened in the cab was not intentional as far as...
I'm going to stop you there because you say not intentional. So it was tight quarters, it was maybe an accident, maybe you brushed against him. That's what we're saying?
Yes, ma'am.
So then why would you make a statement when you got out of the cab, what happens in there stays in there, and then take another shot for his groin area?
Again, because with the relationship between this trooper and I mean, he's done the same thing to me multiple times. It had been happened to me multiple times. I didn't know that he had taken it to the level that it was.
So it was an acceptable practice between the two of you in a horseplay kind of way?
I felt like it was, yes.
So, but you're saying that I don't know what happened in the cab. This was an acceptable thing. I'm not saying that I did anything in there. But when we got out, there's commentary about it. It just doesn't make sense.
No, I'm saying that more than I don't remember the exact details of how I hit his penis. But it wasn't purposely. It wasn't for gratification or to assault him.
But you did know it happened. At the time you got out of the semi on the road where the video is recording you, you did know that something had happened. There had been some type of contact within the cab.
Yes, ma'am.
Right? And so then you make a statement to him about what happens in there stays in there because is he uncomfortable? Has he said something to you?
Yeah, so we had talked coming out of the cab. You can hear on his audio as well the conversation. He was upset.
And so then when you get to the first IA interview and they're asking you about this, you're saying, I don't know, I don't recall, I don't know what happened, even though he confronts you at the time of the incident about whatever had taken place in there.
I had told them that based on the evidence that was there, because it's obvious that something did occur that made him uncomfortable, that something happened. But I wasn't comfortable with telling them, again, it's trying to be, it seems like I'm really just trying to withhold something, but it's not. I just don't feel comfortable saying it was the forehand, it was my hand, because it was very quick. It was an intense situation. It was a report of a stolen semi-truck that we were all kind of rushing to get there and then kind of downplayed after. And so we quit the inventory and we're all hopping out of the cab.
Any further questions? Were there any criminal charges filed against on the sexual battery? Or give me some history on the charge of the sexual battery.
I was charges for sexual battery and aggravated assault were given to the Utah County Sheriff's Office. Both charges were, I'm sorry, I don't know the terminology. They weren't they were sent forward to the sexual battery was sent forward to the attorney's office, and the attorney sent a letter of declination he felt that based off his experience that the jury would nullify based on the circumstances, and he had also asked Trooper Edding, or the other trooper involved, if he wanted to continue with the charges, and he said no.
Is it appropriate for me to ask the investigator a question? Can I do that? I'd like to ask, this is a revocation, it's the only one that we've got today, and so this means forever. Can you tell me why this is a recommendation on this particular case?
So the line under jury is there's multiple accounts where he was asked specifically if something happened.
He was asked multiple times specifically if something happened or didn't happen. The most clear-cut one is when he was asked if he had ever pointed his taser at this other trooper, and he said no. He said he pointed his foot. Then later on, he stated that due to the culture of the section he was working, it happened multiple times. So there's a clear lie. I don't know how you would say or forget that you've done it multiple times if you're freely admitting it at second line. As far as the handgun being pointed, it was a conversation that happened between Mr. Park and Denning, and he had called him a second time, and he actually admitted to pointing the handgun at him. The investigator for UHP then said, well, we're still going to have a Garrity interview, so I'm not going to continue down this conversation anymore. In the interview, the following, I think it was a few days later, he stated that he did not point it at him. When I asked him specifically, he said he didn't know why. During our Garrity interview, I was like, why did you make that statement and say you pointed it at him? He says, I don't know. So again, it's clear that he's making statements, clear statements in one Garrity interview, and then contradicting them and making other statements during another Garrity interview. So there's a clear violation of the Garrity laws. As far as to clarify also with the criminal charges, the charge of the sexual battery, it was left to, the prosecutor said he would go forward with it, but he left the decision to the victim, and the victim says, I do not want to go forward. Mr. Park is correct. In the other stuff, as far as the pointing of the taser, they figured that it would be hard because it would seem like horseplay, and it would be hard to overcome that.
Okay, I think we should let him respond. I would like one clarification. The victim, you call him a victim, the person involved with the sexual battery, is that the same person that's involved with the taser?
Yes, there's two individuals on the taser. One, the taser was pointed at his eye. The laser shined into his eye. He got extremely mad. Mr. Park confronted him on it. Mr. Park says he didn't recall that ever happening. The officer's like, I don't know how that could be because I challenged him directly. And then the multiple times he was had his taser pointed, it was at the same individual as the sexual battery.
Mr. Park.
So, again, I'd love to play the audio for the phone call between Lieutenant Denny and I. I've never admitted to pointing my duty. I've never said I pointed the gun at him. It wasn't in our conversation. As far as the taser incident between Trooper Golding and I, who to this day I didn't know that I had shined it in his eye at my first internal affairs investigation. That was the information. Was that, do you recall ever shining your laser in the eye of Trooper Golding? And I didn't know that I had shined him. Again, not saying that we had never horseplayed with the taser, but I didn't know that I had shined him in the eye. And the second interview, they brought it up again. He had a lot more information. He said he called and got the story from Trooper Golding. And that's what kind of spun the wheel in my head, because I did remember Trooper Golding really kind of coming after me and really getting irritated at it. And like I said, at the time, I hadn't known that I had even shined it in his eye. But that was the event that was being brought up that he had been talking about.
Ms. Vitti, anything additional?
No, thank you. I think it's all there.
With that, I'm going to go ahead and call for a motion. Do I have a motion?
Motion.
accept the recommendation.
I have a motion from Spence Austin to accept post-staff recommendation. Do I have a second? I have a second from Victoria McFarland. Any additional discussion? Hearing none, I'll go ahead and call for the vote. Those in favor?
Aye.
Any opposed? Seeing none, the motion passes. Thank you.
Okay, the next case is Rodney Purvis. Mr. Purvis or his attorney present. No one present?
No one present.
Okay. Rodney Purvis is unemployed. The sustained allegation is driving while ability impaired, which is a Category D offense. The range for this offense is 3 months to 2.5 years. The guidelines baseline is 1 year suspension, and post is recommending a 2-year suspension. The aggravator in this case is that he has a previous post suspension in 17-90. There are no mitigators. There was a criminal case. He pleaded guilty to driving while ability impaired. On December 30th, 2019, Rodney Purvis was investigated for driving under the influence of alcohol. He was stopped for a traffic violation and declined to participate in any roadside sobriety test. He was arrested for DUI and refused to take an intoxilizer test. He pled guilty to driving while ability impaired under Colorado state law, which is equivalent to impaired driving under Utah state law. He did not participate in the post investigation. He had a previous post suspension in September 2018. An order of default was entered because he failed to respond to the notice of agency action. That's all.
Any questions for Ms. Beatty? Seeing none, I'll go ahead and call for a motion.
I make the motion we accept the recommendations of post for a 2-year suspension for Mr. Purvis.
I have a motion from Chief Silk to accept post staff recommendation. Do I have a second?
Second it.
Second from John Crowley. Any additional discussion? Hearing none, I'll go ahead and call for the vote. Those in favor? Aye. Any opposed? Was that an opposed or? Okay, so I'll let your hand go up there. Thank you. It passes. Thank you.
Okay, are we ready for the next case?
Yeah.
No. Okay.
There's no one else here, Al.
There's no one here.
For Taylor Scruggs?
Correct.
Okay. Taylor Scruggs was employed by the Unified Police Department. The sustained allegation was threats of violence and disorderly conduct. These are category C and F violations. The range is 9 months to 3.5 years. The guidelines baseline is 2 years, and post is recommending 2 years. There are no aggravators and there are no mitigators. A criminal case was not filed in this case. Taylor Scruggs, a law enforcement officer, made threats while on the phone with the crisis line worker at UNI to go over to a sergeant's residence and lieutenant's residence and shoot them. The threats reached a point where the crisis worker felt obligated to notify the police. Scruggs became so angry with the crisis worker for reporting this to the police that she felt it necessary to request an officer to respond to UNI for the safety of the UNI employees. An officer from Scruggs' agency and another local agency responded to Scruggs' residence. Both noted indicators of intoxication, but Scruggs denied having consumed any alcohol. During the internal investigation, Scruggs told his agency that the threats were the result of new medication he had just been put on and provided a letter from his doctor supporting that statement. On September 31st, 2018, UPD placed Scruggs on administrative leave. On March 1st, 2019, Scruggs was terminated from UPD based on that incident. Scruggs did not participate in the post-investigation. Post discovered that the FDA recommends people taking Seroquel, which was the drug in question, that if they were taking it, they should not use alcohol, and that using alcohol could cause agitation and aggression if used while taking this drug. Scruggs failed to respond to the notice of agency action, and an order of default was entered against Scruggs. That's all.
Any questions for Ms. Beatty? Hearing none, I'll go ahead and call for a motion. Do we have a motion?
This is Chief Swanson. I'll go ahead and make a motion to accept council's recommendation, or post recommendation.
I have a motion from Chief Swanson to accept staff's recommendation. Do I have a second?
I'll second it.
I have a second from John Crowley. Any further discussion? Hearing none, we'll go ahead and call for a vote. Those in favor? Aye. Any opposed? Seeing none, the motion carries. Thank you.
Okay, last case is Lindsay Smith. Is Lindsay Smith present?
She's
Counsel
participating virtually.
Yes, I'm right here.
Okay, thank you.
Ms. Smith, you are participating virtually. Is that what I understand?
Yes.
Okay. Go ahead, Ms. Beatty, and then we'll give you a moment after to speak.
Okay.
Lindsay Smith was a dispatcher employed by the St. George Police Department. This substantiated allegation was DUI. This is a Category D offense. The range is 3 months to 2.5 years, and the guidelines baseline is 1 year. Post is recommending 1.5 years. The aggravator in this case is that the alcohol content was 2 times the legal limit. There are no mitigators, and there was no criminal case. On September 2nd, 2019, Lindsay Smith drove her vehicle to work while intoxicated. After arriving at work, Smith's behavior led fellow employees to question Smith about being impaired. WorkMed was called, and Smith was asked to provide 2 breath samples that tested .133 and .094. During the Department Garrity interview, Smith admitted to drinking early in the day. On September 18, 2019, Smith resigned her employment. She did participate in the post-Garrity interview and confirmed she had consumed multiple servings of alcohol earlier in the day. She stated that looking back, she was impaired and should not have driven or gone to work that night. No criminal investigation was conducted, and she waived her right to a hearing. That's all.
Ms. Smith.
Yes. I don't have a whole lot to say. It has been a year since that incident occurred. I have since moved on. I think the hardest part of it is the embarrassment of all the work that's put into my case, the incident that did happen, the time and effort of all the interviews, and for you guys to also be happy to discuss this issue. But like I said, it was a year ago. I learned. I loved my job as a dispatcher, and I'm grateful for the things that I learned. It's actually helped me with my career now that I have, and it is something that I regret continuously, but I try not to ruin it. I've just continued to be a mom and keep going on. So just appreciate the time today. I'm sorry I couldn't come up to Salt Lake, but I thank you for this opportunity.
Thank you. Any questions?
Yeah, Chief Swanson, I got a question for staff. Just, I thought I heard there was no criminal investigation, but it's listed as a DUI. Can you clarify that?
Me?
Yes, it was
no, for staff. This is for staff.
It was considered a DUI because she had driven to work. After arriving on work, she had 2 flat tires. They brought her in and questioned her. And the they called, I don't think it was WorkMed, but the organization, her agency called in the medical. They have a machine that's calibrated. It's not the same one we use in law enforcement, but it's calibrated and checked. It showed her as twice the legal limit. They chose not to pursue any criminal charges and just returned her home. But multiple witnesses saw her driving her car, and she admitted to driving her car to work. And then they checked her and tested her immediately upon that at that time.
Okay, so you're just administratively calling this a DUI. I understand.
Correct.
So if I may, just to clarify, the statute only requires that they engage in acts that would constitute a violation of the state or federal statute. So here, this individual engaged in acts that would constitute a violation of driving while under the influence of alcohol. The individual operated a motor vehicle, and we know that from the tests that this individual was under the influence of alcohol at the time.
Yeah, no, I understand. I just wanted a clarification, and I'm ready to go ahead and make a motion. My motion is to accept staff's recommendation.
I have a motion from Chief Swanson to accept staff recommendation.
Second.
I've got a second from Chief Silk. Any further discussion?
This is Sheriff Curtis. Can we make it from the time of when she resigned?
Yes. So we'll have to.
Usually backdate to the date of separation.
So that would be backdated from the time of the offense.
August 2018.
And that's August of 2019. September.
She resigned on September 18th of 2019.
Okay. With that, we'll go ahead and call for the vote. Those in favor? Aye. Any opposed? Seeing none, motion carries. Thank you.
Thanks, Ms. Smith.
That's the last case. That was the last case.